So yeah, there's more than 60 of us here. I think we can prepare to start just to keep within the timeline, okay? I'll be
Sure,
taking the share screen and I'll be asking you, Sylvia, to step in at all times necessary, okay?
sure.
Perfect.
Absolutely.
So let's go, and I think this is an official welcome everybody to this webinar. I know it's very summer in terms of what it's felt like, but it's only the beginning of summer. Thank you for sharing this time with us. And speaking of us, this is a webinar co-hosted by Miro and Accace, and the two guys in front of you, which kind of look like their pictures, are myself and Silvio. I'll
Yeah,
let you
yeah,
do the honors with the intro, Silvio.
yeah. Thanks. Thank you, Bogdan. So, my name is Silvio Constantin. I'm the legal director in a case, and I manage the corporate and legal advisory practice here in Romania. Um, I wanted to join Bogdan today to speak a little bit about, I mean, in the context of the whole turmoil in the Romanian market, especially regarding the fiscal modifications and the increased burdens on employers. Knowing it's summer, as Bogdan said, and that in the third quarter, the autumn, start of autumn, some companies may start building their budgets. I felt that it's the perfect time to strategize and to see whether or not some cost reductions or some workforce restructuring may make sense. And when Bogdan and our colleagues from Miro said that they are looking forward to hosting this webinar, I felt like it's the perfect match for co-hosting it because it ties very good into the performance management and the whole Miro culture thing.
Yeah, thanks for that. So I think it's my turn. I'm Bogdan Yanica. I'm the Chief Product Officer at Miro. As some of you know, and the others, I hope will find out, we're a performance management and overall, hire to retire employee experience platform. And performance management has been this thing that everybody kind of wants to get close to, but people sometimes find themselves stuck into, operational or sometimes legal issues. This is why we we decided to talk about these things together since we are in sync about them. And yeah, I think it's maybe there's a joke to be made about an engineer and a lawyer walking into a bar, but we'll find more about that later. Um, just so you guys know what we have in store for today, this is the agenda. So we will be kind of, I'll try to sum up what I've seen in the market, right? We talk to a lot of people in terms of what does not only a tech solution look for performance management, but how do processes look like, right? And out of this, out of some big, engagement, or dare I say, disengagement of people, there's this entire hype about how performance management is failing to keep up to date. Then we'll be covering the legal aspects of it because most of you guys, I assume, would work in the HR department, and some questions that bounce back from the initiatives we try to have together are, is this compliant? How is this mandatory? What makes it not a nice to have, but a business imperative, right? So at least from a compliance or legal standpoint, we will be trying to make the best out of combining legal expertise with product expertise and hopeful that something good will come out of this. Okay. So you will be spending just this one more slide or just a couple of more with me, just trying to frame up the logic, the business logic that we're in, and then I'll pass the mic back to Silvio to kind of highlight three main areas about compliance in terms of performance management. Okay. Um, Myself and our team, we're constantly, at the since you were talking about periods of the year, at different points in time, we're looking at what are the big trends, right, in performance management, in the HR practice in general. And what we're seeing is not great, frankly speaking. I mean, we've had big disengagement trends, like the one with the Great Resignation. Nothing great about that, right? The one with the quiet quitting, then the quiet firing, which was the exact opposite of it. And now we're seeing that Gartner at least specified that people are, quietly doing just their job and not focused on performing, right? And it was kind of weird to us because the tools seem to be the same. You need continuous feedback. You need to like align people on how they're doing the job. You need recognition, which is still a problem after all of these years. It seems that we have a problem in saying thank you and job well done. And then you need transparency and alignment. And for some reason or the other, it seems that this is kind of where we're at a standstill, right? And talking to some people, it was at times, taken into the legal or compliance aspects of things because we try to create engagement into the performance process. We try to make it as personal as possible so that people, feel attracted to get involved into the performance management process. The companies would win on the other hand side. Things like voluntary leave would decrease, leading to gaining some money in terms of cost of replacement, but it feels like it's not enough. And one of the big reasons we're seeing thrown back at us, right back at us, I'm absolutely sure that on the other side of this screen is people who are again just like we feel in the middle of this, in the middle of this fight, in trying to make good for their people, in trying to make good for the company, but sometimes some things bounce back. And we're trying to focus on the things that are directly legal or compliance related into this process of performance management. So just for that, I'm gonna hand it over with full confidence to Silvio, and please take it away.
Yeah, thank you, Bogdan. So, as you looking at the performance evaluation from a legal standpoint, one of the most common issues in the whole process is the process owners' failure to understand the fact that what they do actually have legal and what how they approach it actually have very palpable legal implications. Right, their approach has very palpable legal implications. Now, we, as so myself as a lawyer, and we are as lawyers, are trained to always look at risks, right? And the main risk we encounter in these types of situations are, as seen on the screen, are twofold. First of all, the first risk that may stem from the performance evaluation is a potential accusation of discrimination and harassment. Now, this is no secret anymore. Romania has been on the verge of very, let's say, very effervescent anti-discrimination and anti-harassment law. And if you look at the whole context, we have five legal streams in the form of the labor law, law number 2202 on dash 2002, the government emergency ordinance 167, and a couple of more ordinances on the methodology of harassment prevention. Now I can very easily let them in the chat, but these are more technical. Now, as we all know, the performance management is not always just ticking some boxes and measuring some KPIs, and most of the time they involve the more subjective elements, things like attitude and teamwork and communication and overall behavior. Yes, these soft skills tend to matter as much as productivity metrics, but if you ask me, the owners of the performance management process should always focus on the hard facts, because if they don't, or when they don't, if they are not fully prepared to do what it takes or how to properly approach the whole process, employees who are becoming increasingly more aware of their rights will turn to harassment and shout discrimination because they don't like the feedback or they don't like the result of the assessment. Now, um, if we look at the risks, the direct risks of the in terms of harassment and discrimination, these are three, right? It's the first one is the moral damages. So basically, employees can claim moral damages in both court and outside of court, arguing that they felt harassed and discriminated by their line manager or by some colleagues which have provided false feedback in their opinion. um, we even have had some recent cases when an employee was being fairly toxic, but he was the one arguing that he's a victim of mobbing. I believe he said, like, people gathered against him even though he was the toxic one. The second one is the fines. Now, fines are not that big of a deal, but they can come paired by labor inspections, which, because the authorities take very very seriously the harassment and discrimination claims, and tend to look at all the matters of all the nuances of the organization, and they tend to dig up everything. And perhaps the most important ones are the reputational damage. Now, a scandal in terms of discrimination, similar to whistleblower, can break a company. Even though, I mean, remember what happened with the professor recently in Romania, with the politics professor. Now, looking at the second one, the the second risk is the undermining of a future sanctioning or dismissal process. Now, we often see in practice the fact that you end up tainting the water for eventual dismissal, to the point where the entire process becomes compromised and you are no longer to sanction a low performer in any meaningful way. Now, let me give you a scenario. Let's say you have an employee who is clearly underperforming. You've done your homework, you have all the right tools in place, the policies are solid, the procedures are aligned, the performance criteria are clear and objective, as you said earlier, and also the KPIs have been clearly communicated in a transparent and meaningful way. However, the people involved in the performance review are not fully aware of what they're supposed to do, and they start focusing on subjective impressions. Perhaps they forget to document critical incidents, or we even had the case in which some friendly colleagues of the employee provided glowing feedback to the employee, even though they were completely disconnected from the actual performance metrics. This is something most of our clients struggle with. Now, suddenly your case, which you felt like you had it all together, starts falling apart, right? So what do? Do you place him on a PIP, on a performance improvement plan? He will argue that this is discrimination, especially if previous reviews were positive, and if he argues that, let's say, his line manager has a personal grudge on him or her. Do you withhold his annual bonus or reject his promotion? He will most likely claim that this is unfair sanction because no one informed him of updated expectation or gave proper feedback in previous performance review. Now, let's think of the worst case scenario in which you decide to fire him. You initiate a dismissal you initiate the dismissal for professional unfitness. He will appeal it in court, and you are faced with the risk of the court reinstating him because you don't have everything properly in place. Now, this is the cost of a poorly executed process, not because the employee was performing highly, because he wasn't, but because the process wasn't documented or the procedures weren't followed consistently. Now, moving on, or if you could go to the next slide, um, there are ways to prevent this, obviously. Now, if you have everything in order, assuming you need, the first step and foremost is arguably the most important one is to ensure that your regulatory framework is properly set up. You need your internal regulation to be correct and to accurately reflect your company's internal processes. You need to have properly set up and documented performance review process. You need to have all the performance assessment criteria and KPIs communicated to the employee during onboarding as per the provisions of Article 17, but also regularly afterwards, because these tend to change and the targets are mobile, as we all know. And my recommendation would be to do it at least every half year, but yearly it's just fine. You need to set up your anti-harassment and anti-discrimination policies so as to be in line with the proper legislation, and also need to set up the reporting channels and to perform the training of the employees. I mean, these are all mandatory. Now, if you don't know how you stand, and this is for everybody listening to us right now, you should perform a quick audit or a comprehensive audit, but perhaps a quick health check, and have your lawyers look at it and see whether or not there is anything needed there. I mean, this is non-negotiable. You should do this yesterday if you haven't done so already. Assuming you have all these things properly set up, the next step would be to make sure that your managers and individuals involved in the process are trained so as to avoid biased or subjective language. The Romanian Labor Code prohibits any form of direct or indirect discrimination at work, along with all the other laws, such as Law 202 and the government ordinances regulating discrimination and harassment. All of these forbid differential treatment. Now, if your manager labels someone as difficult to work with or not the right culture fit without any job-related context, they may, intentionally or not, be expressing bias that could later be challenged in court. What we advise our clients to do is always, as I said, always focus on the metrics. You are free to obviously assess the soft skills, because these are, as I said, very important. But if you are faced, or should I say, if you're looking to build something, then yes, you should focus on perhaps focus more on soft skills and culture and nurture that employee to empower him to grow. And this Bogdan is mostly your area. But the way we look at it, we look at the, unfortunately and cynically, we look at the what could go bad. And when we look at what could go bad, we tend to safeguard the organization from toxic employees. And this is why I encourage that for these problematic employees, always look on the hard facts so as to be prepared in case the whole thing escalates and we turn to a dispute. If we assess a toxic employee or a low performer or someone who is not culturally fit, he's not actually culturally fit, on soft skills, we may be faced with the scenario in which we have our hands tied and cannot do anything to basically get rid of him or sanction him in any meaningful way, as I said earlier. Also, one of the most important things you need to do is document everything. Document every feedback, every decision, every prior assessment, and every incident that may arise before the check-in and afterwards, because this will allow your lawyers to use them and to protect the organization in case of a dispute. Yeah,
Sorry to interrupt you. Would I be wrong as to say that, you know, in order to cover for I don't want to scare people away to feel like this is super hard to achieve. What I get from this is that some things are like very clear drawn, like an audit, which I think you can guys can provide for the
yeah,
people right here, right? This is your part of your specialty. And
yep,
some things, to me, it seems like they are very, you know, part of a continuous process, like teaching managers to, you know, be objective about performance, constantly investing into management lines and this documentation, which, yeah, my now that I'm putting my engineer hat on, you would be super helped by a system to document everything and have actual part of the documentation already done by the people using that system, right? So it's
absolutely.
audit plus way of working, right?
I mean, what? Yeah, perhaps I'm being very doomy and gloomy, but yeah, as I said, the audit part is, or let's say the compliance part is like a prerequisite. You get it done, you put it in place, you put a framework in place, and then you start building on it. And when you start building on it, you build in terms of making people aware and training the stakeholders and so on and so forth. So yes, absolutely, they go hand in hand. Some parts are, I mean, there is no part less important than the other, and this is why I gave the example with the scenario in which you have everything done perfectly, but if you don't have the training and you don't have the managers, the line managers, or the persons involved in the process trained and properly aware, it basically amounts to zero. So yeah, they are equally important, and one does not exclude the other. You need to have both of them, and you should have both of them.
Okay.
Yeah.
So
Okay.
there's some
So
work to be done.
yes, it is. It is. But because I mean, if you pay attention to it and do it correctly from the outset, my opinion is that it's very easy to maintain. It's very
Mhm.
easy to what's the word, to keep it compliant and keep it good. But you need to start from somewhere, and you need to start from a healthy base.
Okay,
Okay,
absolutely.
so
Yeah,
going further, if you could go to the next slide, Bogdan.
yeah.
So we have the offboarding, right? So we spoke. I mean, I touched a little bit on what happens if you have a low performer and you actually need to be able to sanction him or her in a meaningful way. Now there are a few. I will not spend too much time on these types, on the types of upwarding, because they are known by everybody. We have the let's say two big types, unilaterally and mutually agreed. The MTA is what we always aim for. Just keep in mind that you can conclude at any time for any date. Is quite often that we learn from our clients that they negotiate with the employer termination plan date, but wait until the last few days to actually conclude it, actually sign it, because they said that they wanted for the notice. They wanted the notice period to elapse. Now, there is no notice period in mutually agreed terminations, assuming they wish to allow for some time to facilitate the transition for both parties. Obviously, you should sign it immediately as soon as you have an agreement, but set up the effective date at a later date. Now, this poses no difficulties. Everybody surely is very familiar with it. The second one is the one I wish to talk about is termination for professional unfitness. This is the means of sanctioning a low performer. Uh, Although it's the main tool, it's the most challenging ways to end an employment contract in Romania. In simple terms, this happens when an employee is no longer fit for the job, not because of misconduct or bad behavior, but because they can't meet the role's requirements. Romanian labor law allows this under Article 61, letter D. Yes. and but stops there. It doesn't provide for any guidance. The whole guidance stems from the case law and the technical articles in Romania. And it's a very strict process that must be followed step by step, but it's already grounded in the Romanian practice. um, I will not go in detail because I had prepared the content, but I think I am going to into a little bit much of a detail here. Um, just keep in mind that you need to let your lawyers do it, but until then, you need to have everything in place. You need to have all the things we discussed earlier. You need to have very clear and measurable KPIs, and you need to be able to prove that you have brought them to the attention of the employees. You need to prove that the assessment has been done objectively and on time, and you need to prove that that individual, despite being given all the cues and resources and instructions and possibilities, failed to meet the expected quota. Moreover, there is the performance improvement plan. It's not mandatory to have the termination decision pass, but it usually for the courts in case of disputes matter a lot whether or not the employee has been included in a PIP before. So my advice is do the PIP, do it short. You don't have to do it very long, but do it because this is the way you make sure to not have the decision dismissed. Because obviously everybody knows what happens if a termination decision is dismissed. You have to is yeah rejected in court. You have to reinstate the employee, give him back pay, give him all the legal costs, and so on and so forth. The second one is the disciplinary dismissal. Once again, I'm sure that everybody's familiar with it. It's a sanction that comes from when the employee is doing some misdemeanors, let's say. It requires a very formal process, the appointing of a disciplinary committee, investigating the alleged misconduct, hearing the employee defense, and issuing the recommendation that precedes the decision. What I want to point here is that um, this is highly subjective. The court has broad discretion on whether the deed is grave enough to warrant the dismissal, which is why I never tend to recommend going this path. What may be useful is initiating the investigation, but trying to negotiate the MTA regardless. Because if you end up in court, it's a dice throw, and nobody can guarantee that one party will win or not. What you can do to improve a little bit is list unacceptable behaviors in the internal regulations, in the internal regulation or the dedicated disciplinary policy, making it clear that certain acts, such as insubordination or breach of confidentiality or workplace bullying, are considered grave offenses and warrant immediate termination. But even in this case, you may end up with a court or judge, a sympathetic judge, saying, "Yeah, this is not grave enough, and you should reinstate the employee." Finally, my favorite ways of terminating an employment contract is the redundancy. This is because it doesn't target the employee himself or herself. It targets the job, the underlying job position. If one could argue that there are legitimate reasons for abolishing the position held by employee X or Y or Z, then you don't really need to rely on any specific traits of the employee or any performance of the employee if you are unable to prove, for example, that he is being a low performer. You need, however, to have a real and serious cause, and but the law stops there, and the courts will assess whether your cause is real and serious enough, but that does not have the competence to go into specific business decision of the employer. Sorry. So imagine this. Imagine that you wish your company has poor financial performance in the prior year, needs to dismiss some of the job positions, and is free to do so. But what happens if it had profit the previous year? In that case, you are also able to dismiss some to abolish some positions, because it's your business decision. I mean, I can go on and on, but I don't want to stop on this. Why it is important is because this is the base for the whole reorganization process. And if you could go to the next slide, Bogdan. The reorganization is assuming, let's say, you have a strategy to reduce costs for the next year. You are making your budget in the autumn, as I anticipated, or as I know some of our clients do in the third quarter. By the end of the third quarter, you may want to look at possible reorganization scenarios, and you need to know whether or not you are able to do so. And do know that if you have legitimate business interest, it's not financial hardship. It can be operational, it can be strategy, it can be opportunity, it can be anything. As I said, the court is unable to scrutinize it. Then yes, you can start abolishing position and firing said employees. Now, what you have to be careful with is selecting those. If you, let's say, have 10 or 20 IT programmer positions, and you wish to fire 5 indiscriminatory, then you need to be able to prove that those 5 you selected are the ones that should have gone in the first place. So you need to have some objective criteria for selecting those. If you have different positions, then they're different position, and you are able to select which positions, as long as you are able to argue it, to ground it. And the second thing you need to pay attention to is if you surpass certain thresholds, you will fall under the collective dismissal regime, and you have some additional obligations, like notification of the labor inspectorate and a few more others. But once again, I won't go into any more details on this. So some key takeaways from here is: make sure you do your performance management process every time. Make sure you have all the policies, procedures, and internal regulations and rules in place, and make sure that all the criteria you use are being used transparently and objectively. Try to avoid going into, or try to train your colleagues, the line managers, to avoid going into very specific subjective topics and rely to the KPIs. But for this, you need to devise and make sure that you have these KPIs communicated very clearly and very transparently to the employees. So basically, this is what I wanted to say. Obviously, if there are any more questions, I will happily answer them. I hope I didn't bore you too much with the legalese.
Yeah, thank you, Silvio. At some point, I wanted to keep up, and then you used the letter of the law, and but thank you for the key takeaways. That's super important that you mentioned them, and also from what I got. So you clearly expressed the risks. Of course, we'll be able to share this presentation with the people here. There's a lot of us still present, which is great. And I'm seeing some questions popping up. We have a Q&A session right afterwards. So we have the risks, we have the some audit about how Silvio would see this process from a legal perspective at least. And then we have some details about what happens when things go wrong, basically. Even so, if wrong is individually or is business generated, regardless if it's a business risk or it's just a business decision, like in strategy, right? But we're not just talking about numbers here, and this is the part where I kind of keep you for 5 more minutes to tell you that as we've seen, and it's been super up there in the media lately, every decision like this creates like a collective bandwagon on external media jumps on it. More and more people from within the company jump on this bandwagon of unfairness, disengagement, risks. Of course, it's very personal for someone to lose their jobs, but we have to think from the perspective of the company here as well, right? So basically, the reason why jobs exist is because some people have put them out there and are trying to do the best for their company, and this is like normal life, and it's up to us to see how these decisions, sometimes necessary, impact the culture as well. That's my part of the story here, right? With this, I think the main message here on my behalf would be just to treat each other like adults and be super fair, transparent about it. We need to kind of show people where we're going and why. And then in terms of individual performance, I think one key aspect we're mentioning, Silvio twice, myself at least twice, is to invest in your management lines because they're a key figure right here, right? From our point of view as a platform, we're trying to give managers to put them on this, forefront of our efforts to try to educate them in order to lead performance management, and also from their middleman perspective to understand it as an employee as well. Okay, cultures are usually affected about everyone coming in or going out, but as feedback has a ratio of 5 to 1, you need 5 times the effort to amend things if someone has gone out, especially if they were let's say informal leaders. um We've been working together. Again, maybe this is something we haven't emphasized enough, myself and Silvio. We work together in Miro and Accace, and we've seen some things, going the right way. One of them would be voluntary turnover, which has gone very well for us. But one other thing, and Silvio, I think I'm gonna let you talk about it, is how you perceived the app once you got your account, because you got Miro already in your company and you felt like the entire experience. How was it?
Yeah, so I started talking there, but was on mute. So yeah, as a user myself, at first I was a little bit skeptical, but then when I actually started using it due to my position, I was very pleased with it. I mean, it did allow me to basically it served me everything on a plate, right? I needed to do that. It was super intuitive. Just went to the performance tab, just do the check-ins, have everything notified me, have all the let's say the leave requests and the flexible work requests, and so on and so forth. So in terms of performance, it's super easy to use because you can either initiate it yourself and have your manager initiate the feedback request, and then it basically has this 3 or 4 step process for you to just move from one to another. You just hit next as you go about, and yeah, it lets you do everything in order, and you cannot really mess it up. And also, what I like is the fact that you are able to select what types of question you can ask. Right, you have those 4 or 5 types of questionnaire, and
Mhm.
these are very easy to fit on what you need for that specific employee of yours or colleague of yours, or even for yourself. Right. So I had this project. How was it for up until now? What I learned from it, and yeah, it's I like it a lot.
Yeah, thank you. And this is kind of big for us because at all times we wanted to be, as friendly as possible with the user, with the employee, at the end of the day. So we've tried to kind of gather all the data that's possible and actually help people use the platform more and more so they have more data to their performance. So in you saying that it's legally compliant, that's a big plus for us. People might confuse the fact that you can't actually do engagement while still keeping it, while still keeping things engaging. And I think this is what I am, for one, actually challenging here. It's probably even healthier to let people do their thing as long as you know that these functions like feedback, like recognition, OKRs or objectives management in general, and performance check-ins, whatever their type, stay interviews, performance reviews, or stuff like that. These attract the people to use them more and more, which also gives the company the chance to have a very transparent process and a very clear process. Okay.
So Bogdan, 1 second about the objectives. You have them on the slide here.
Yeah.
I This is one of my favorite parts and my team's favorite part because we all love seeing those bars fill up because we set up the objectives and the KPIs, the underlying KPIs, sorry, the subsequent KPIs to that objective, and we all align with our own objectives, which we priorly agree. And yeah, it's once done, they are there, and we are. It's very easy to track. So yeah, this is one feature that we really like.
Yeah, OKRs is like, to me, it's doing things twofold. On the one hand, there's alignment and clarity into why are we going into that direction, and on the other is what do I have personally, what I can do, to help the company and how I will be evaluated in terms of, my output, not just only my brilliant personality or something like that. Okay. Uh, Speaking of one thing that we've managed to keep, as a big differentiator for Miro was actually from all of these interactions, some of them super functional, as you said, Silvio, on the OKRs and their subsequent KPIs, on performance interactions. We're trying to map out the entire process. We're trying to map out the entire company precisely to give people and decision makers the information about how important is one or the other to the culture, and in order to avoid biases, if you put it that way, because maybe we're having to make do with people that won't fit from a performance perspective or from a behavioral perspective, but we know that they might be connected. What we're trying to do with Miro is actually, give you hints about who is more engaged with the others and what that effect might be if you look at everyone's impact. Now, I was absolutely sure, and we almost did a bet, which I would have lost, that we go over time with with this webinar. I'm trying to use the best out of our remaining 5 to maximum 10 minutes to take some questions from you guys, since I'm already seeing some messages here. I hope that's okay with everyone, and feel free to use the chat or the Q&A. I'm seeing one question from Diana here. How short is still big enough pip, right?
Yeah, so I think this should be for me. In Romania, we don't really have this, let's say, this grounded practice of performance improvement plans, which is why we don't have them regulated anywhere. However, it does have to be long enough to actually be meaningful, but it highly depends on what type of activity you want to see improved, right? If you want to improve a big process, you cannot improve it in 30 days. You may need a whole quarter, right? 90 days. It usually doesn't go over 90 days. But if you are faced with a low performer and it's an execution position and you really want to be able to map out the fact or single out the facts which is lacking, then I would say that 30 days to 45 days is more than enough because during this time you would set up let's say a very high rhythm of one-to-one meetings and supervision on tasks and so on and so forth, and you will be able to highlight those lackings or those failures so as to warrant the low performer conclusion.
Okay, fair enough. And Diana, I
Yeah.
hope we answered your question. Well, Sylvia did. From a software standpoint, think it can be as long as you want it. If there's no other questions, or until we have more questions, I would want to ask, the big tech questions nowadays. How does using AI in performance management, adhere to the legal matters? What's the big no-no in using AI for engagement, for performance, for everything employee related?
So we have the AI Act, which is going to be implemented in phases. I'm actually undertaking a course on this right now, and the first module of the course, it's like a 6 month course. The first module of the course was specifically for HR and recruitment use cases, and basically this is one of the more sensible areas. You have like 4 areas, and each layer has its own specific requirements. HR, I think, is tier 2. Basically, you cannot allow it to make decisions by itself. You cannot prompt it, or let's say train it, sorry, in a way that would allow it to judge by itself and take reach conclusions by itself, which you will use as is, right? You will need to have it supervised. You will need to have human input. It's a huge help. Myself, I also use a lot of the AI tools available, but I wouldn't leave it by that. I mean, I wouldn't leave it alone to do its own thing. Anyway, I would still supervise it, despite the fact that certain, let's say, certain tools nowadays are super powerful and may very well help a lot with the automizations of the reviews, and let's say some feedback, or highlighting specific terms or notions from the feedback the individual receives. Now,
Yeah.
once again, in terms of, this is from an AI Act standpoint. From a local legislation standpoint, there are no rules. Basically, if you collect information generated by AI, and that information is correct, because it usually is correct if you train it well enough, the let's say error percent is very low, then is it it's possible to prove in court that this is actually the case, and no one will ask, where did you get the information? Did you get it from AI, or did you get it from your HR colleagues or the line manager? No, and they will not
Mhm.
be able to prove either way.
So
So I think we have
we
what would you
have
say?
one, let's say AI related, and maybe we go to that one first, and then Jana's or Jana's question should be the last, since we're
So,
running
is
out
it
of
legally
time on
accepted
this one.
that I give AI a description and ask to rewrite it according to legal requirements? So, I'm not sure whether I understand when you say give AI a description of for performance management. Okay,
Could I step in just a
yeah.
bit and say, if we have, let's say, we use AI for information retrieval, which is okay. We don't have the time to read everything, and a short description should be well enough, right? Served to a human being. We use it for retrieval. We use it for interpretation, like this all making it more, consistent and more easy to use. And then we can use AI for data creation, or generating content, which I think is something that is quite of a no-no, right? You can't have it speak on behalf of a manager or on behalf of an employee. I would differentiate between these two.
I mean, yes, you are correct. It's just that when it comes to your employees, even the data retrieval may become sensible,
Okay.
because you may be confronted with a case. I mean, think of a CV screening, right, for recruitment purposes. If you tune your AI tool to screen out some of the CVs that do not contain certain information, or that do contain certain notions or terms or anything, then this is strictly forbidden by the law,
Mm-hmm.
by the AI Act. Now, it's not as bad to use it for generating content and have it generate some conclusions, or crack down a database and see crunch some numbers and retrieve some conclusions from there. This is less dangerous. It's more dangerous to leave, because when it screens out CVs, you basically take it out of the pile, take this batch out of the pile. It already reached a decision for you.
Yeah.
It limited your CVs, because your candidate, your hire, may have been a candidate from the pile it threw out, and this is why the law requires
So that was already decision making. Whether putting some
exactly
information in front of
because it
the manager or the HR isn't decision making, it's just presentation, right?
exactly.
Okay, got it. I
So
think we
we
can
have.
get one more question from the one with the severance package. And
Okay, what is the severance package Romania in case of MA performance related minimum maximum common? Thank you. There is no severance package regulated by the law, so there is absolutely no limitation. Uh, in terms of practice, depending on the employee, the seniority, and the it's not related to the stream or the cause of the dismissal. Is related mostly to the seniority of the employee and basically how bad the organization wants him out or her out. We have been a standard practice would be to go from, let's say, 5 monthly salaries worth of compensation. Just keep in mind that any amount must be grossed up, and the employees tend to look a little bit too much to, let's say, US based movies in which settlements are in the numbers of millions, and it's not the case for Romania. But we have been required to negotiate. Let's say someone asked for 72 monthly salaries recently.
oh,
Yeah.
okay.
I mean, it was egregious. But keep in mind that this is entirely up to the parties' negotiation, and there is no legal requirement whatsoever.
Okay.
Okay, so to
Um,
summarize the conclusion on AI performance management, we would not let it take decisions regarding scoring, but okay, for qualitative content creation, yes, no is enough. Yes, you are correct, Diana. Okay, so
and
I think this is the time, Bogdan.
yeah, I think
Otherwise,
it's
we will
time.
be
And
faced with the interruption of the of the
yeah,
webinar.
please leave us your feedback. And I do assume that some feedback would be to do this again with you, Silvio. So bad luck. uh, as a former
It's my
president
pleasure,
would
man.
say. But I do think that it's something that we should talk about more often and not run away from. Not everything compliance or legal is scary, and sometimes it might be even helpful in order to give people, a very nice performance management type of experience, which is also helpful in the legal matters.
Yeah,
So thank you everyone. It's been the webinar with the most people attending. I'm super happy and grateful for all of you being here. Thank you a lot, Silvio, for your time and your expertise as
likewise.
usual. I was used to him, not at this level yet, but yeah, feel free to reach out, leave us your feedback, and we'll be back with the presentation and the recording, I think, for all of you. And we're, I think, one email away. Both our teams are here to stay and here to work together. from now on. Thank you so much,
Absolutely.
everyone.
Thank you, Bogdan.